order to prosecute her for illegal drug use. The police exceeded the scope of the consent Reedy had provided for a search of her person. Having examined the language of the consent forms from the perspective of an objectively reasonable person in Reedy's circumstances, we conclude that someone who had not been accused of committing any crime and who had arrived at the hospital to be examined for the purpose of evaluating the extent of her injuries and risk of disease from a sexual assault, and for the purpose of gathering physical evidence to prosecute her assailant, would not understand that she was also consenting to having her blood tested a second time for drugs, at the direction of a law enforcement agent, for the purpose of collecting evidence to prosecute her. Time of search. A consent to search may also be limited with respect to time. For example, in United States v. Alcantar, 271, F. 3D 731, 2001, the court found an hour-long search of defendant's vehicle for drugs and weapons permissible because 1. The defendant did not object to a search of this length, and 2. 1 hour was reasonable in light of the fact that drugs and weapons can easily be concealed inside a vehicle. In addition, in United States v. Carvajal 586, F. 3D 795, 802, 10. SIR 2009, the court found that police searches of the defendant's vehicle in 2 locations, the second of which involved a canine search, and that in total lasted approximately 2 hours, did not exceed the scope of the defendant's consent to search. The court reached this conclusion because the defendant had provided police with consent on multiple occasions, did not limit his consent to search to a specific time period, and police acted as diligently as they could in conducting the searches. His search here did not exceed the duration of defendant Carvajal Iriarte's consent. Carvajal Iriarte characterizes the search as occurring in 2 different locations over a span of 2 hours. This description ignores the multiple consents to search given by Carvajal Iriarte. That Carvajal Iriarte repeatedly consented to these searches favors the conclusion that the duration of the search was reasonable. The first search at the truck stop lasted approximately half an hour, after which Carvajal Iriarte agreed to go with Agent Small and Detective Tate to meet Officer Ramos for a second search. After arriving at Officer Ramos's location along Interstate 40, Carvajal Iriarte reaffirmed his consent for the search. From the time of Carvajal Iriarte's last consent, the search lasted just over an hour. Once Officer Rui Loba arrived with the drug dog, the dog alerted to the presence of methamphetamine within a matter of minutes. Carvajal Iriarte's consent contained no limitation on the duration of the search and can only be described as giving the officers general permission to search the vehicle. At no time did Carvajal Iriarte seek to limit the duration of the search. NL. Part 3. Exceptions to the search warrant requirement, nor did the officers create the understanding that the search would be brief. It is also noteworthy that Carvajal Iriarte's last consent was provided after voluntarily traveling to meet another officer for the express purpose of a search. Finally, there is no indication that the officers failed to act with due diligence in conducting the search. In light of all of these circumstances, the search was of a duration permitted by.
Welcome to the stream. Good morning, everyone. Uniquely Mia here. Right now, I'm doing some criminal justice reading, chapter 9. This chapter is all about consent searches. I will be making a separate video about it. However, did wanted to live stream it in case you guys want to see what's it like to read textbook chapters and jot down notes simultaneously. I know there has been some criminal justice interest on the channel, so if you listen very closely, you're going to be able to understand what my laptop is reading to me. Right now it's going over United States v. Carbalate search, where a police officer essentially conducted a search on a defendant for multiple hours. So make sure to like the video and stay tuned for more criminal justice videos.
By Carvajal Iriarte's consent. United States v. Carvajal Iriarte suggests that if police are planning to conduct multiple consent searches pertaining to the same defendant at multiple locations over the span of a few hours, they should attempt to obtain consent to search from defendant on more than one occasion. For example, before each search and or at each new search location. In State v. Brachu, 237A, 2D 418, Me 1967. Officers investigating the death of the defendant's wife obtained a valid consent from the defendant to search his home. The officers conducted a search and found nothing. At that time, the defendant had not been accused of anything. Later in the day, however, police received information giving them probable cause to arrest the defendant for his wife's murder and to obtain a search warrant for his premises. They arrested the defendant that evening and executed the search warrant. The next day, the defendant successfully challenged the validity of this warrant by asserting that certain items seized by police were not mentioned in the warrant, and the prosecution at that point attempted to justify the second search on the basis that the defendant's earlier consent continued in effect after his arrest to the next day. The court rejected this contention because the defendant's status had changed between the two searches from that of a concerned husband to that of the accused in his wife's murder. The consent from the first search, in our view, should be measured on the morning of the following day by the status of the defendant as the accused. There is no evidence whatsoever that the consent for the first search was ever discussed with defendant at or after his arrest, or that he was informed of the state's intent to enter and search his home a second time. On the strength of a continuing consent, we conclude, therefore, that consent of the defendant had ended by the time of the second search, and accordingly the officers were not protected thereby on the successful second search. 237A, 2D 421. Therefore, if a significant period of time passes after consent to search is given, a new consent should be obtained before continuing to search, especially if intervening events suggest that a second consent might not be given so readily as the original consent. If the suspect does not renew his or her consent, a valid search warrant should be obtained.
So they're saying this is going over voluntary consent. That essentially said, if a defendant or if a suspect gives consent to search, voluntary consent, and a long amount of time has passed, perhaps 1 day has passed, new voluntary consent is needed to search that area. If that voluntary consent isn't acquired, a search warrant is needed. Now I have to write that down. Okay. Because that was a good summary of it. Okay. If they give voluntary consent and 1 day has passed, or more than 1 day. If you guys want to know what the criteria for a search warrant is, check out my educational videos. I made a criminal justice video separate for that, so stay tuned. It's on my channel. Consent, 1 day has passed or more. Voluntary is needed. If they're not acquired, then a search warrant is acquired. Good morning, Drake. Drake said, Mia, it's way too early to be live. I woke up at about 6:20 this morning, Drake. I decided to live stream this just because I know there has been like some criminal justice interest happening. So I decided be cool to stream it for you guys while I'm reading my textbook, so you guys are getting like the raw information that I get, because what I do in my criminal justice videos, I get the raw information from the textbooks, from the lecture videos, and then I summarize it for you guys to make it more straightforward, where you're not reading a lot of cases and a lot of words. So this is what I do to make the videos, so definitely stay tuned. I will be making a video about consent searches. I think this is the video that may be dropping this week and I have to film it, so stay tuned for that. But good morning, how's your day going today, Jake? Or morning. Hello, Clemma, haven't seen you in a while. So the scale of judgment, positive probability, and negative fairness, also uncertainty. Oh, you're trying to summarize the points, 3 points that I just mentioned. Scale of judgment. I mean, I wouldn't say it relate. I mean, I would have to think about it, but based on just reading it and based on what I just read, I don't think that ties directly related to consent searches, but I'll have to look more into that. So let's get
Object of search. If the consenting person places no limit on the scope of a search, the scope is generally defined by its expressed object. Florida v. Jimeno, 500 U.S. 248, 251, 1991. Therefore, a search may be as broad as the officer's previously acquired knowledge about the crimes likely to have been committed and the items of evidence likely to be discovered. United States v. Seeley, 630 F. Sup. 801, ed. Cal. 1986. The U.S. Supreme Court's opinion in Jimeno, discussed earlier, provides an example of how the stated object, or purpose, of a search can determine that search's scope. In Jimeno, a police officer was following the defendant's car after overhearing the defendant arranging what appeared to be a drug transaction. The officer stopped the defendant's car for a traffic and
remember, the defendant is the suspect, guys, okay? It's important to remember that when we're reading this so we don't get confused. Hey, Superman, good morning, good morning. Boring content. I find this content to be interesting, in my opinion. But, like, yeah, if you're not a criminal justice person, maybe watch some of my criminal justice videos, Superman. So go to my YouTube homepage, click playlist, and watch those videos because I summarize them really nicely for you. What you're hearing now is my textbook content. And even though I do enjoy the feel of criminal justice, sometimes some chapters are boring. But yeah, definitely watch my videos, and hopefully that is more entertaining and makes you want to learn more about criminal justice. Good morning, Boss Stacks. Glad you could tune in this morning. How's your morning going?
infraction and declared that he had reason to believe that the defendant was carrying narcotics in the car. The officer asked permission to search the car for drugs and received the defendant's consent.
Good morning, Michelle.
During the search, the officer found cocaine inside a folded paper bag on the car's floorboard. The court held that a criminal suspect's Fourth Amendment right to be free from unreasonable searches is not violated when, after the suspect gives a police officer consent to search his or her automobile, the officer opens a closed container found within the car that might reasonably hold the object of the search. In other words, the court believed that in light of the stated object of the consent search, a search for drugs, the officer was permitted to look for drugs in a paper bag because this bag could contain drugs.
Moral of this story, guys, if you come in contact with a law enforcement officer, always be respectful, obviously, but you have the option of voluntary consenting for them to search your car, your belongings, or even your home in some circumstances. And when I say that, and that voluntary circumstances or that voluntary consent can be given verbally or non-verbally. So imagine a scenario, guys. You are pulled over by a law enforcement officer, perhaps for a general speeding ticket, right? And then randomly the law enforcement officer asks, hey, can you open like your trunk for me so I can look into it? If you open that trunk without saying anything, you voluntarily consented for that search to occur. So later on, if you come and try to sue that law, let's say NYPD, if you come and try and sue the NYPD, if the traffic stop happening in New York, you may not win that lawsuit because you did voluntary consent to that search. Obviously, there can be other circumstances around it, but nonverbal cues exist. However, let's say you're pulled over, they ask to open the trunk, and you're like, no, I do not voluntarily, no, I would not like you to search my trunk without a search warrant. They can go ahead and still search your trunk, but if you bring a lawsuit, you may have grounds to get whatever evidence found. It can be dismissed in court. If you submit like a motion to suppress for it, it can be dismissed because you didn't voluntarily consent. So fun facts for you guys. Oh, like, I'm not telling you guys this information to, like, if you're pulled over and a law enforcement officer come to you and you're going to be hostile and be like, no, you can't search my car because uniquely Mia told me this. No, guys, these are just ideas in the back of your head that you can say it. Law enforcement officers, they can do whatever they want, but saying these stuff, if they violate your rights, decide to sue them, you may have grounds for winning. But then again, I'm not an attorney. This is just what I'm learning, and I'm just interpreting it in ways that are understandable for me. So verbal and nonverbal cues are very important, guys. So always voice your opinions verbally. And just like always have a recording happening too. That's always good. Boss Stacks, my morning is going well. I'm just listening and learning with you this morning. Okay, glad your morning's going well, and welcome, welcome. Let's listen and learn together. Let's get back to it.
Drugs. On the other hand, if the stated object of the automobile search had been a person or another object of equal size, the court would likely have held that the search of the bag was unconstitutional. United.
Let's listen to that again. Let's go back.
The bag was unconstitutional. If the stated object of the automobile search had been a person or another object of equal size, the court would likely have held that the search of the bag was unconstitutional.
Why? Was it out of scope of the search? Let's see what it says. If the consenting person places no limits on the scope of the search, the scope is generally defined by its express object. Okay, so Supreme Court case Florida v. Jamero found that therefore a search may be as broad as the officer's previously acquired knowledge about the crimes likely to occur. Okay, so if the officer had previously acquired knowledge that contraband would be found, contraband are things like drugs, they're really small. Don't search like a big area perhaps. Let's see, crimes likely being committed, items found likely to be discovered. Okay, this other Supreme Court case, how an object stated, purpose, search can determine the search's scope. Police officers was following defendant's car and overheard the defendant arranging what appeared to be, okay, a drug transaction. The officer stopped the defendant's car for a traffic infraction and declared that he had reason to believe that the defendant was carrying narcotics in the car. Okay, the officer asked permission to search the car for drugs and received the defendant's consent. During the search, the officer found cocaine in a folded paper bag and the car's floorboard. The court held the criminal searches were admitted, right? Researches not violated. Okay, that makes sense. Okay. Okay, that makes sense. All right.
Unconstitutional. United States v. Rodney, 956, F. 2D 295, DC Sir 1992, held that a request to conduct a body search for drugs reasonably includes a request to conduct some search of the crotch area. Thus, if police obtain voluntary consent from a suspect to search his or her body for drugs, they may conduct a reasonable search of the suspect's crotch area because drug dealers frequently hide drugs near their genitals. Note that the objective reasonableness standard depends on the facts of each case. A general consent to search a particular area of a vehicle does not necessarily allow the search of all containers in that area of the vehicle. For example,
best bet, guys, if you ever come in contact with law enforcement officers and they're going to listen to you, always request to have a search conducted, whether of your properties under a search warrant, because search warrants set parameters on what and where and how an officer conducted a search. Because when you generally give voluntary consent, there is a concern and a little bit of worry that officers can go outside the scope of that search and violate your Fourth Amendment rights. So search is conducted under a warrant, in my opinion, based on what I've learned. Best way to go.
Example, consent to search the trunk of a car may not include authorization to pry open a locked briefcase. J inside the trunk. As the court noted in Jimeno, it is very likely unreasonable think that a suspect, by consenting to the search of his trunk, has agreed to breaking open of a locked briefcase within the trunk, but it is otherwise with respect to a closed paper bag. 500 U.S. at 251-52. Lower courts, however, have permitted searches of locked containers as well as hidden compartments and containers within vehicles when the defendant provides consent to both a complete search of his vehicle and to the seizure of any property contained within it. For example, in United States v. Reeves, 6, F. 3D 660, 662, 9th SIR 1993, the defendant signed a consent form allowing police to conduct a complete search of the car and seize poppers and other items contained within it. On these facts, the court found that a search of a locked briefcase in the hatchback area of the car and the removal of contraband from that briefcase was within the scope of defendant's consent. See also, United States v. Garcia, 604, F. 3D 186, 189-91, 5th. SIR 2010, Garcia did not qualify his consent to the officers, who therefore had general consent to search the truck. When the officers requested permission to search the truck after asking Garcia whether he was carrying anything illegal, it was natural to conclude that they might look for hidden compartments or containers, including the area within a stereo speaker in the cab of the truck. In sum, the search of Garcia's truck cab was reasonable. The district court did not clearly err in denying the motion to suppress the cocaine police found within the speaker in the cab. And when an individual provides police with valid consent to search an entire container in his or her possession, the police may permissibly search additional containers found within that container. For example, in United States v. Jackson, 598 F. 3D 340, 343, 348.
Como said, central possibility, then the always precision notion. I'll have to look up that. I haven't heard of that before, Clemo, but thank you so much for providing me with that new knowledge. I'll do some research on that. Hey, good morning, Stew Lover Kitchen. Peace upon you as well. Right now we are doing some criminal justice reading. I'm kind of showing you guys behind the scenes the raw criminal justice data that I acquire, which then I like to spruce it up or like make it more understandable and post it in videos for you guys. So in this chapter, we are going over consent searches.
For example, in United States v. Jackson, 598 F. 3D 340, 343, 348-49, 7th SIR 2010, when an officer received valid consent from defendant's mother to search a case for a computer and its serial number, the court held that the scope of the officer's search could extend to a zipped exterior pocket on the case. The district court properly concluded that Officer Dexheimer did not exceed the scope of defendant's mother's, Eaton's consent. Where someone validly consents to a general search, law enforcement may search anywhere within the general area where the sought-after item could be concealed. Eaton consented to the officer's request to search the bag, and she placed no limit on the extent of the search. Furthermore, to the extent defendant argues that the objective of the search limited the scope of Eaton's consent, Officer Dexheimer was searching not only for a computer, but also for evidence of the computer's serial number. That serial number, together with the power cord and other computer equipment, could have been located anywhere in the computer case, including in the exterior pocket. As such, Officer Dexheimer did not exceed the scope of Eaton's consent. 387, Chapter 9, Consent Searches. 388, Part 3, Exceptions to TR Warrant Rule. Of course, the consenting person may specifically limit the scope of a consent search to a search for a particular object. In People v. Superior.
Heard that? Consenting person may specifically limit the scope of a consent search to search for a particular object. So remember earlier when I told you guys, don't commit crimes, but if like you're suspected of a crime or like you're an innocent individual and like law enforcement officer knocking your door like, hey, I want to search your home. I recommend, if they were to do that to me, I'm never going to commit a crime. Don't see myself committing a crime in the future. But like if a random law enforcement officer would ever come to my home and be like, hey, can I search your home? I would request the search to happen under a search warrant. Why? Because a search warrant sets specific parameters on the scope of the search. That means where the officer can search, how the search should be conducted, when the search should be conducted. So if they go outside of that scope and I want to sue them, I have valid grounds to do that and documentation. However, when you give voluntary consent, guys, it's voluntary consent. The officer just walked up to your door and knocked. There's no legal paperwork beforehand. So they generally have free will. They can search and do whatever they want. And sometimes that can lead to violations of the Fourth Amendment right, searches and seizures. protection against unreasonable searches and seizures. However, as we heard, if you do want to give that voluntary consent, you can set the limit and parameters of the scope. You can be like, hey, yeah, you can definitely search my home. However, you can only search my living room and my kitchen. You can't search my bedroom. Like I said earlier, law enforcement officers, they can do whatever they want. If you set those parameters and you let them into their home to conduct the search and they go outside of your kitchen, your living room, and you want to sue them, you may have valid grounds to do so. You may not. However, you can set the parameters and the limits for the scope or the search to occur based on this information, guys.
Court, Arquita, 89, Cal, RPTR 316, Cal, Act 1970. A person gave officers consent to search his house for a crime suspect. The officers instead conducted a thorough search of the house and its closets for a crowbar without advising the person that they wanted to look for a crowbar. The court invalidated the search because it went beyond the scope of the consent.
What I just said. This individual allowed officers into their home to search for a crowbar in like one specific area. Officers went out of the scope, searched the whole house. The search was invalidated in court.
Granted. Also, in United States v. Turner, 169, F. 3D84, 1999, the police, prior to obtaining defendant's consent, explained that they wanted to search places in his home that might contain physical evidence left by an intruder who had committed a recent assault. Under these circumstances, the court found that the police officer's search of the defendant's computer files fell outside the scope of his consent. The court explained that it obviously would have been impossible to abandon physical evidence, such as a knife or low-3 clothing, in a personal computer hard drive, and bizarre to suppose that the suspect.
Good morning, Haley. Glad you could tune in. I'm from the United States. Where are you from? Right now, I'm doing some criminal justice reading and just elaborating on different things that I find to be interesting or impactful. If you want to acquire some criminal justice knowledge, definitely stay tuned and listen. If this isn't your forte, feel free to definitely like the video. Consider becoming a subscriber/supporter. I also do fashion videos, me technology videos, travel videos. My nails are bare, so I think today I may do like a manicure video for you guys. Haven't done that in a while, so definitely stay tuned. Clemo said shout out to Stefan Derp. Who's that? Clemo said right now I'm on water, then the ginger milk green for the evening in between the usual. Oh, so you're like on a diet, Clemo. Okay, very cool. So you're like on a water diet and a ginger milk. Is that a like ginger milk tea diet?
Suspected intruder stopped to enter incriminating evidence into the Turner computer. 169 F 3D at 88. An invitation to enter premises is not the equivalent of consent to search the premises. Also, a person found to have provided valid consent to one search has not necessarily provided valid consent for additional searches. The scope of a consent search.
You heard that? Permission to enter your home isn't permission to conduct a search. So you gotta be clear with the language.
Search depends on what the typical reasonable person would have understood by the exchange between the officer and the suspect. As a general rule, if an officer asks for and obtains consent to search a specific area, whether in a place or on a person, the officer is limited to that specific area. A person giving consent to search may place a time limitation on the search.
Place a time limit.
A court may infer a time limitation on the person's consent if the role or status of the person changes significantly, i.e., from that of concerned spouse to that of murder suspect. If the consenting person places no limit on the scope of a consent search, the scope is generally defined by its expressed object. The person giving consent to search may revoke or withdraw that consent at any time after the search has begun, although such revocations of consent should be clear and unambiguous. In sum, law enforcement officers should confine their search to only those areas where the object for which they have consent to search could possibly be located, taking into consideration the object's size, shape, and character. Revocation of consent. The person giving consent to search may revoke or withdraw that consent at any time.
So you see, these are some important points we got to remember when you are giving voluntary consent to search your premises, your vehicle, your house without a warrant. you can set the limitations or the parameters of the search. Like I said earlier, you can specifically specify to the officers, yes, you can search my home. However, don't even say, you can be like, hey, yes, you can search my kitchen, my living room, and my garage. This is what I voluntarily consent for you to search. However, you can only search for 1 hour. You can set this time limit. And as they're conducting the search, they said you can revoke the search at any time. If the officers tell you, hey, I'm looking for, what am I looking for? I'm looking for a piano in my search. Why are you opening it? If you're searching like my laundry room, why are you opening my washer? A piano can't fit in my washer. That's outside of the scope of the search. As I said, it can do anything, but based on my textbook, you can set these parameters. If they go outside the parameters, items found, if it's illegal, may be excluded in court.
Time after the search has begun. In State v. Lewis, 611A, 2D69, Me 1992, after arresting the defendant for drunk driving and releasing him on personal recognizance, a state trooper offered to drive the defendant to a nearby motel. When the defendant retrieved a carry-on bag from his car, the trooper asked for and received permission to check the bag for guns. The trooper immediately observed 2 large, brown bags inside the carry-on bag, smelled marijuana, and asked permission to examine the bags. The defendant refused and attempted to return the carry-on bag to his car. The trooper intervened and searched the brown bags. Finding marijuana, the court found that the defendant had revoked his consent to search the carry-on bag before the trooper opened the brown bags. Even though defendant consented to the troopers looking inside his carry-on bag, he at no time consented to the troopers looking into the brown bags contained therein. Rather, by expressly terminating his consent when the trooper requested to open the brown bags and by seeking to return them to his car, defendant most certainly manifested a subjective expectation of privacy with respect to those inside bags. Because those bags were always closed and their contents shielded from the trooper's view, society would regard defendant's expectation of privacy in them to be reasonable. 611A, 2D at 70. In addition, in United States v. Ho, 94F, 3D 932, 933-36, 5th Sir 1996. When the defendant first gave permission for an officer to search a portfolio in his possession and then attempted to pull away the portfolio when the officer found a blank white card that did not appear to be contraband, the court found that the defendant had successfully withdrawn his consent for the officer to search the portfolio. Likewise, United States v. Ibarra, 731 F. Sut 1037, DYO 1990, held that a motorist's closing and locking the trunk of his car after a police officer's prior consensual search of the trunk constituted a revocation of that consent and barred any further search. However, if a motorist, after revoking her consent by closing the trunk, voluntarily reopens it, a court may find that this motorist has 389 voluntarily renewed her consent. See United States v. Flores, 48, F. 3D 467, 468-69, 10th VE, SIR 1995. 4. A revocation of consent to be valid. The suspect must clearly communicate that he or she is revoking consent. Ambiguous revocations may be held to be insufficient to have accomplished the intended revocation. For example, if a suspect merely complains about the length of the search, this fact alone may not constitute revocation of that suspect's consent. See United States v. Brown, 345, F. 3D, 574, 8. SIR 2003. Similarly, in United States v. West, 321, F. 3D 649, 7th. SIR 2003, after the driver of an automobile provided a blanket consent to officers to search a car, the defendant, a passenger in the car, claimed ownership of a particular duffel bag located within the car. The police subsequently found cocaine in the bag. The court held that defendant's claim of ownership, without more, did not revoke the driver's consent to search the car, including the duffel bag. United States v. West stands for the principle that revocation of consent will not be inferred from mere silence. The question on which the lawfulness of the seizure of the cocaine turns is whether the passenger revoked the driver's consent to search the entire car, necessarily including the bag, by the passenger's silence in the face of the driver's consent. The passenger forfeited any right to claim that the consent was ineffective to authorize the search because the bag was his. For example, the passenger's his silence was confirmation or ratification of the driver's authority to consent. 321F 3D at 651-52. Who may give remain. In general, the only person able to give a valid consent to a search is the person whose constitutional privacy protection against unreasonable searches and seizures would be invaded by the search if it were conducted without consent. This means, for example, that when the search of a person's body or clothing is contemplated, only that person can consent to the search. The same rule applies to searches of property, except that when several people have varying degrees of interest in the same property, more than one person may be qualified to give consent to search. Third-party consent under actual or apparent authority. In certain situations, the law recognizes the authority of third persons to consent to a search of property even though they are not the persons against whose interests the search is being conducted. United States v. Matlock, 415, U.S. 164, 1974, static test for determining whether a third person can consent to a search of premises or effects, and the prosecution seeks to justify a warrantless search by proof of right consent. It is not limited to proof that consent was given by defendant, but may show that permission to search was obtained from party who possessed common authority over or other sufficientship to the premises or effects sought to be inspected. 415, U.S. at 171, emphasis added. 390, Part 3, exceptions to the search warrant requirement, actual, common, authority. In a footnote of the Matlock decision, the Supreme Court defined what it meant when it used the term common authority. Authority is, of course, not to be implied from the mere interest party has in the property.
Good
The
morning,
authority
good
which
morning,
justifies the
Anthony.
third
How are you
assent does
doing
not
this
rest upon the
morning?
law of property, with its attendant cal and legal refinements, but rests rather on mutual use property by persons generally having joint access or control for nosed purposes, so that it is reasonable to recognize that any of the cohabitants has the right to permit the inspection in his own right, and others have assumed the risk that one of their number might the common area to be searched. 415, U.S. at 171 N. 7. From this, we discern that someone with actual authority over property has the legal capacity to grant consent to search the property over which he or she has access or control. Apparent, common, authority, in addition to a third party having actual authority to consent to a search of another person's property or effects. A third party may also have apparent authority to do so. For example,
Okay, we're gonna go over, it looks like they have some definitions. Is this gonna read all of it? I gotta read this by myself. Let me see. Common authority is, of course, not to be implied from the mere interest a third party has in the property. The authority which justifies the third party consent does not rest upon the law of property. What did I read? With its attendant, historical, and man, why do they write stuff so weird? And like, when people write in a legal way, that makes no sense. Wait, common authority is, of course, not implied from the mere interest the party has in its property. The authority which justifies the third party consent does not rest upon the law of property. What the world? I think this professor probably elaborated on the lecture videos. I hope he did, because that definition of common authority makes no sense to me. Authority refers to the legal permission granted. Yeah, we're not figuring that out now. There's a lecture video. Let's hope that lecture video clarifies what common authority means.
From this, we discern that someone with actual authority over property has the legal capacity to grant consent to search the property over which he or she has access or control. Apparent, common, authority, in addition to a third party having actual authority to consent to a...
authority. So actual authority is like my mom, she owns her house. She has actual authority to give consent to search this area because she owns it. That's actual authority. So I know what common authority is now. Okay. So if actual authority is saying my mom owns her house, since she owns it, she has actual legal authority to give consent because she controls that property in a way. Common authority, I feel like now, is like maybe a corporation. You have stakeholders who can give that authority. Joint access, I believe. Think so. Not 100% sure. So we're still going to wait for the lecture video. But that makes sense to me. Okay. Authority to search property over which control. Okay. And I'm going to provide my example in there because you never know, I could probably use it somewhere. Okay. So it's saying my mom owns a house. She has actual authority. Okay, what does Steal Our Kitchen say? Common authority could mean someone else that lives in the house. They may not own it, but they live certain rights. That makes sense. Let's see. Common authority. That might be it. Let me see. Common authority is, of course, not to be implied from the mere interests a third party has in the property. Okay, that relates to Steal Our Kitchen with the comment. The authority which justifies the third party consent does not rest upon the law of the property, which its attended historical and legal refinements, but rests rather on mutual. Okay, so that's like the other person who lives in it. Okay, that makes sense. Okay, thanks for that. That helps. Okay, so just a person. You see, you guys are learning stuff too. You just helped me. Okay, living in a property, but does not own it. Okay. So I'm going to wait and look at the lecture video too, and I'll add on to that definition. Good morning, Aiden. How are you doing? Right now, I am reading a criminal justice textbook, chapter 9, all about consent searches. So I'm live streaming it for you guys because I know like you guys are interested, at least some supporters are interested in my criminal justice content. So I'm showing you a little bit behind the scenes, the raw data that I acquire, and then I then take that raw information and then spruce it up, make it pretty, make it more understandable. I pick out the main points and make that into like a 15-minute video for you guys. So that is what we are doing right now. But instead of that 15-minute video, I read everything. And sometimes that takes an hour. I've been reading this since yesterday. This is like 50 pages, I think. So luckily, we don't have 50 pages anymore because I started reading yesterday. But it takes a while. Hey, Ella, good morning. But how are you doing, Aiden? What time is it in the Czech Republic? Good morning, James. Glad you could tune in. How are you doing this morning? Ella, James, would love to know.
A search of another person's property or effect.
We're gonna go back
A to a third party.
because we need to
Having
go
actual
through
authority to consent to a search of
apparent
another
authority.
person's property or effects. A third party may also have apparent authority to do so. For example, a warrantless entry and search is valid when based on the consent of a third party whom the police, at the time of the entry, reasonably believe to possess common authority over the premises but who in fact does not have such authority. This does not suggest that law enforcement officers may always accept a person's invitation to enter premises.
Stop reading. Why you stop reading for?
Apparent, common, authority, in addition to a third party, having actual authority to consent to a search of another person's property or effects. A third party may also have apparent authority to do so. For example, a warrantless entry and search is valid when based on
Apparent common authority is a third party having the actual authority to consent to a search of another person's property. Let's see. A warrantless entry and search is valid when based on the consent of a third party whom the police at the time of entry reasonably believe to possess common authority, but who in fact does not. Okay.
On the consent of a third party whom the
I'm literally
police,
gonna write
at
that
the
quote
time
down.
of the entry, reasonably believe to possess common authority over the premises but who in fact does not have such authority. This does not suggest that law enforcement officers may always accept a person's invitation to enter premises.
So guys, educate whoever you have in your home. Make sure they're educated on if an officer comes to, don't commit crimes, but make sure whoever you have in your home, a friend, a family member, whoever visits you, lives there, just put in a group text and be like, if you guys are ever at my home and law enforcement officers come and if you want a search to happen under the scope of a warrant, make sure you tell your guests, make sure you tell your family members, don't give consent to enter my home, because if they give consent to enter your home, voluntary consent to search, you implicitly agreed. And if they find nothing, hopefully they don't find nothing. Don't commit crimes, God. Though I'm telling you this information just so you have the knowledge, not to convince you to commit crimes, because crimes isn't good. You will be caught in the United States criminal justice system if you commit crimes, okay? But if you do commit a crime and you have illegal contraband in your unit, in your home, and your friend lets them in the unit, if they voluntary consent to that search, you voluntary consent to that search. So yeah. A warrantless entry and search is valid when based on the consent. I feel like that's a disclaimer I should start putting in my videos, because I know I do have international supporters. All the criminal justice information I'm telling you guys is based on the United States criminal justice system. If you live abroad, it could be similar. However, there are going to be differences because I'm only learning about the United States criminal justice system. So I'll start putting those disclaimers in my videos. Good morning, Michael. Oh, you're waiting for the bus to go to school? Okay, wow, this is early. Well, 7:44. What time does your school start? That's early. Well, then again, my school starts whenever I wake up, and sometimes I wake up at 5, sometimes I wake up at 4. So have a great day at school, Michael. Hopefully you learn a lot. It's Friday. Hopefully you're excited about that. I mean, I have to work a 24-hour RA shift today, so yay. But it's gonna be, hopefully it's a quiet night tonight when I have the phone. So hopefully you have a great weekend, Michael, and have a great day at school. Right now I'm reading about criminal justice consent searches. Consent of a third party. actually going to film the criminal justice content for you guys. I mean, I like talking about it. It's fun to me to speak about criminal justice topics. It's just sometimes it's a lot to record it and I have to edit it. So that's why there has been a delay on criminal justice videos for you guys. The thing about it, I have to bulk film because what I've been doing, I've been filming like one video a week sometimes, but I have to bulk film because when I find free time to record videos, if I don't bulk film, it's not going to get done anytime soon since I read a lot in my classes. So stay tuned, guys.
Rodriguez has been construed as a plea, cable, to situations in which an officer would have had valid consent to search if the facts were as he reasonably believed them to be. United States v. Whitfield, 939 F. 2D 1071, 1074, DC Sir 1991. Rodriguez would not validate, however, a search based on an erroneous view of the law. For example, an officer's erroneous belief that landlords are generally authorized to consent to a search of a tenant's premises could not provide the authorization necessary for a warrantless search. Proving actual or apparent common authority, the prosecution has the burden of showing that someone consented and that the person had actual or apparent authority to do so. Therefore, law enforcement officers must provide sufficient evidence of both consent and authority to the prosecuting attorney for presentation in court. Mutual, or common, authority involving third parties generally comes from spouses and persons involved in similar partnerships.
Generally comes from spouses. So tell your spouses your preferences, guys, okay? On how you want a search to be conducted. Michael said, I'm waiting for the bus. It's colder than a witch's heart out here. How do you know a witch heart is cold, though? Witches could be good, right? But it sounds like, I guess it's freezing then. But why do witches gotta be bad, guys? Okay. I was gonna write something down. Oh, I was gonna write down third parties are generally people's spouses. Or it could be like your parents, your friends, whoever you live with, guys.
Partnerships, but also occurs in roommate, parent-child, employee-employer, and other relationships.
Employee-employer, what?
Law enforcement
That's so
advisors
weird.
should ask reasonable questions designed to show a relationship of such common authority that either party has the right to consent to the shared real or personal property. And, of course, the answers received must reasonably show such a relation. 300.
Well, no, employer-employee makes sense because, like, if an officer goes to a corporation, I imagine the employee would then be the spokesperson. Yeah. So, yeah, that makes sense to me now.
391 ship. Reasonable.
Or would be the person who can give that voluntary consent since they work within that area.
Reasonableness, not perfection, is the standard on which the officer's behavior is hot-dead measured. Officers are not required to be correct in their deduction.
I guess if you are like a corporation owner, business owner, make sure your employees are compensated really well so they don't voluntarily consent for you guys. That's funny. But, like, yeah, make sure they're compensated really well and that they're happy, guys. So, except, like, I don't know, if officers come to your area of employment, they don't want a search to happen, you know your employee's not going to snitch on you and have a search happen.
Deductions concerning one's i.e. authority to consent, but they must act. Deductions concerning one's i.e. authority to consent, but they must act in good faith and reasonably, based on training and experience. Specific types of third-party
So these
consent.
are a list.
The remainder of this chapter.
I'm not going to write down this list, but I am going to put a note on where it can be found because it may be useful to me later on.
Chapter examines examples of consent
lot.
search situations in which the person giving the consent is not the person against whose interests the search is being conducted. Therefore, in each of these examples, the central question is whether the person providing consent has common authority, whether actual or apparent, over the searched premises or effect such that the person is capable of providing valid consent. The following examples will be explored. Persons having equal rights or interests in property, landlords and tenants, hotel management and guests, hosts and guests, employers and employees, school officials and students, principals and agents, spouses, parents and children, drivers and passengers, and bailers and bailees, persons having equal rights or interests in property, for example, co-owners, co-tenants, co-renters, or co-lessees. It is well settled that, when two or more persons have substantially equal rights of ownership, occupancy, or other possessory interest in property to be searched or seized, any one of the persons may legally authorize a search, and any evidence found may be used against any of the other persons.
See
In
what I just
determining
said?
whether a
You've
person
heard
is
that?
a joint occupant of premises, i.e., co-tenant, co-lessee, etc., with the capacity to give valid consent, courts consider enough.
That's a good page. I'm gonna make sure I go back to that page. It could be useful in like discussion posts or like essays. I have highlight. I need to buy more highlighters, guys. All my highlighters are like scattered. I can't even go to Walmart today to get them. This is an ugly color. I don't like this color.
Number of factors: M. Whether the person paid rent. M. How long the person stayed. M. Whether the person left belongings on the premises. M. Whether the person possessed a key. And M. Whether there was any written or oral agreement among other parties as to the person's right to use and occupy the premises. For example, the court, in United States v. Kelly, 953, F. 2D 562, 9th. SIR 1992, found authority to consent to a search of the defendant's bedroom and closet under the following circumstances. M. The person giving consent had rented the apartment together with the defendant and had signed the lease. M. She described herself as the defendant's roommate. And M. She had joint access not only to the common areas of the apartment but also to the defendant's separate bedroom, where the apartment telephone was located. Common NNN. Part 3. Exceptions to the search warrant requirement. Moreover, in United States v. Matlock, 415, U.S. 164, 1975, previously discussed, when the person providing consent to search a room slept there regularly with defendant and stored her clothing there, the court found that this person had actual authority to consent to a search of that room, including containers within that room. However, in Illinois v. Rodriguez, 497, U.S. 177, 1990, the U.S. Supreme Court held that the defendant's former co-tenant did not have actual authority to grant police consent to enter the defendant's premises without a warrant, even though she had some furniture and household effects in the premises and sometimes spent the night at the premises after.
Okay, good morning, Terrifier. I got that one. Terrifier's type in a Guyanese accent. I'm morning, beautiful girl. Sorry, good morning, good morning. Glad you could tune in. Thank you so much. Oh, brilliant. Thank you so much for your kind words, Terrifier. What are you saying? I think that means you all right. Are you okay? You're asking me if I'm all right. Yes, I am doing good this morning. I am doing all right. Thank you so much. How are you doing? Right now I am doing some criminal justice reading if you've just tuned into the stream. So this video is honestly criminal justice focused. So definitely stay tuned. Certain points I'm elaborating on certain topics. We're on page 392. And this goes all the way, this chapter goes all the way to 407, 409, I believe. So we have a few more pages left, but not a lot. Finish line is almost there. Once I'm done with this, I am going to go and look at my public administration notes from my class yesterday and just like translate some of those notes into like a pages document for myself. So definitely stay tuned if you guys want to see me typing and if you want to learn about like criminal justice content.
After moving out a month before the search at issue, the court found that the former co-tenant lacked actual authority because her name was not on the lease. She did not contribute to the rent. She was not allowed to invite others to the apartment on her own. She never went to the premises when the defendant was not at home. She had moved her clothing and that of her children from the premises, and she had taken a key to the premises without the defendant's knowledge. These facts convinced the court that the former co-tenant did not possess actual authority to consent to the search of defendant's apartment, though the court did remand the case to the lower court to determine if the co-tenant had apparent authority to consent. For example, whether the officers could have reasonably believed the former co-tenant had authority to consent. However, even when valid consent is obtained by police from one co-occupant, i.e., a co-owner or co-tenant, to search a residence on a particular occasion, when another co-occupant of that residence is physically present on this occasion and refuses to consent. Police may not enter the residence without a warrant or the presence of some other exception to the warrant requirement, i.e., exigent circumstances such as probable cause to believe someone is being or soon will be harmed. If police nonetheless enter and search the residence based on the one co-occupant's consent, the physically present and objecting co-occupant has the right to have the search declared unreasonable and any evidence seized against him excluded in court. Georgia v. Randolph. 547 U.S. 103, 2006. For further discussion of this case and its implications, see the subsequent discussion point and the criminal procedure in action box later in this section. In addition, the U.S. Supreme Court recently considered whether Randolph applies if the objecting occupant is absent when another occupant consents. Fernandez v. California, 134 SCT 1126. 1129-30, 2014. The court.
And just note, I'll reiterate it, search warrants, generally needed. Search warrants or voluntary consent is generally needed when officers enter into somebody's home or space. However, as the book said, exigent circumstances, that essentially means an officer has probable cause to believe that if they do not enter into this unit right now, somebody will be harmed. That is always it's a good enough reason 9 times out of 10 for officers to enter into that space without a warrant, because they are doing so to protect somebody.
Court in Fernandez answered this question in the negative, finding that police may search residential premises when one co-occupant consents in the absence of the objecting occupant.
Let's see what we got. Let's move down here.
Of course, if the police have probable cause to believe one of the exigencies previously listed actually exists, then they may enter the residence without a warrant or consent, and any evidence they find in plain view may be seized. See Chapter 10 for further discussion of the plain view doctrine. In addition, police may use information obtained from an encounter with the cooperating and consenting co-occupant to obtain a valid search warrant, despite noting this emergency exception to the Fourth Amendment warrant requirement. The court held that no such emergency was present in this case. Nothing in the record justifies the search at the court in Randolph said that if a potential defendant with self-interest in objecting is in fact at the door of the residence and objects, the co-tenant's permission does not suffice for a reasonable search, whereas, if the potential objector is nearby but not invited to take part in the threshold colloquy or exchange at the door, the objector loses out. For example, the objector can neither have the search deemed unlawful, nor any evidence seized during the search excluded. Do you agree that the physical presence requirement is a sound requirement? For example, why shouldn't the police have to make a reasonable effort to find and seek the consent of co-occupants who are not physically present at the on grounds independent of Janet Randolph's consent? The state does not argue that she gave any indication to the police of a need for protection inside the house that might have justified entry into the portion of the premises where the police found the powdery straw, which, if lawfully seized, could have been used when attempting to establish probable cause for the warrant issued later. Nor does the state claim that the entry and search should be upheld under the rubric of exigent circumstances, owing to some apprehension by the police officers that Scott Randolph would destroy evidence of drug use before any warrant could be obtained. 547 U.S. at 123 time consent to search is requested. Might these co-occupants, once found, object to the search? Should the holding, or rule, of Randolph apply only to residences, or should it apply to other objects and locations, such as business offices, vehicles, storage units and/or duffel bags? In this regard, consider what the court said in dicta in United States v. Murphy, 516 F. 3D 1117, 1124, 9th Sir 2008, abrogated on other grounds by Fernandez, 134 SCT at 1126. Moreover, even if the storage units could not be considered a residence, there is no reason that the rule in Randolph should be limited to residences. Randolph is rooted in the idea of common authority, and the Supreme Court has extended the principle of common authority well beyond residences. In Frazier v. Cobb, 394 U.S. 731, 740, 1969, the court held that the shared use of a duffel bag was enough to give rise to common authority between users such that either user could give lawful consent to a search. Item 740, 89 SCT 1420. Certainly, business offices are also subject to the protection of the Fourth Amendment. See Mancusi v. DeForte, 392 U.S. 364, 369, 1968. Do you agree or disagree with the court's holding in Randolph? Fully explain your answer. Do you believe the court's holding in Randolph means that victims or potential victims of violence will be less likely to receive police assistance in preventing or stopping such violence? Fully explain your answer. Landlords and tenants. A landlord has no implied actual or apparent authority to consent to a search of a tenant's premises or a seizure of the tenant's property during the period of the tenancy.
You see? So if you're a landlord, guys, you, according to this book, you do not have authority to give consent, voluntary consent, for officers to search your tenant's unit. Yes. So we're going to write that down. But according to that, you do not have authority to do that.
Tenancy. Even though the landlord has the authority to enter the tenant's premises for the limited purposes of inspection, performance of repairs, or housekeeping services. Chapman v. United States, 365 U.S. 610, 1961. Once the tenant has abandoned the premises or the tenancy has otherwise terminated, however, and the landlord has regained the primary right to occupation and control, the landlord may consent to a search of the premises, even though the former tenant left personal belongings on the premises. United States v. Sledge, 650 F. 2D 1075, 9th Sir 1981. See also United States v. Law, 528 F. 3D 888, 900 405, DC Sir 2008. Furthermore, because a landlord clearly has joint authority over and access to common areas of an apartment building, a landlord may give valid consent to search those areas. United States v. Kelly, 551 F. 2D 760, 8th Sir 1977. See also United States v. Elliott, 50 F. 3D 180, 187, 1995. Finally, landlords who maintain joint or common authority with tenants over a specific area of premises may give consent to a search of the area even if not actually bought. EE 396. Part 3. Exceptions to the search warrant requirement. Using it at the time of the search. In United States v. Cook, 530, F. 2D 145, 7. Sir 1976. The defendant's landlady consented to a search of a poultry house on her property. The poultry house consisted of a large room in which the landlady had segregated an area with wire fence for her exclusive use. She gave the defendant permission to use the remaining space, but she retained the right to use that space if necessary. The defendant claimed that because neither the landlady nor her family had actually used the defendant's area, there was no common authority. The court upheld the search. However, ruling that the defendant had assumed the risk that the landlady would permit others to inspect the premises, including his shared area of the room, hotel, management and guests. The U.S. Supreme Court held that the principles governing a landlord's consent to a search of tenants' premises apply to consent searches of hotel rooms allowed by hotel managers. In Stoner v. California, 376. U.S. 483, 1964. Police investigating a robbery went to the defendant's hotel and, in his absence, obtained permission from the hotel clerk to search his room. The police found items of evidence in the room incriminating the defendant in the robbery. The court held that the search was illegal and that the items seized were inadmissible. The defendant's constitutional right was at stake here, not the clerk's or the hotel's right. Therefore, only the defendant, either directly or through an agent, could waive that right. The police had no basis whatsoever to believe that the defendant authorized the night clerk to permit the police to search his room.
So essentially, let's elaborate on that really quickly. So we said the landlord part, we're not going to say that again. But if you live in a hotel, well, not live in a hotel, but like if you rent the hotel, right? According to the Stoner v. California 1964 case, hotel managers, hotel clerks, hotel employees, they cannot give voluntary consent for you to allow officers to search your hotel room. Why? Because if you pay for a hotel room for one night, 2 days, a week, when you're paying for that, that then becomes your form of a home, and you kind of have ownership over that space or authority over that space. And since hotel employees, hotel clerks, they're not living in that space with you, nor are they paying for that space, they're unable to give the voluntary consent to enter into that space, according to this.
Moreover, the concept of hotel guest has been given a broad interpretation by courts. For example, in United States v. Kimiana, 383 F. 3D 1215, 10th Sir 2004, the court found that although the defendant had not registered or paid for the hotel room, he could still validly consent to a search of that room because he had stayed there overnight, left his possessions there, and carried a key to the room. According to the court, these facts support a finding that defendant had joint access or control over the room, and thus had actual authority to consent. 383 F. 3D at 1222. See also United States v. Rodriguez, 414 F. 3D 837, 844, 8th Sir 2005. Person who had neither paid for nor registered for motel room could validly consent to search of room because she was the only person who lived there. When the term of a hotel guest's occupancy of a room expires, however, the guest loses the exclusive right to privacy in the room, whether or not the guest remains in the room. The hotel manager then has the right to enter the room and may consent to a search of the room and a seizure of items found in the room. United States v. Larson, 760 F. 2D 852, 8th Sir 1985. See also United States v. Lanier, 636 F. 3D 228, 232-33, 6th Sir 2011. Hosts and guests. The host's authority to consent to a search of the guest's area of the premises depends on m. the length of time of the guest's stay, m. the exclusiveness of the guest's control of a particular area of the premises, and m. the guest's reasonable expectation of privacy in that area of the premises. In general, the owner or primary occupant of the premises, the host, may validly consent to a search of the premises, and any evidence found is admissible against a guest. 397 on the premises. For example, in United States Whitehall, 979, F. 2D77, 6th Sir 1992, the REID owner of a residence gave consent to search the room of the defendant, whom he had allowed to stay at his residence, in exchange for farm work. The court held that the owner had authority to consent to the search when he owned all the furniture in the room. He had personal items stored in an adjacent room accessed through the dance room. The room was never locked, and there was no agreement between him and the defendant that he was not to go in the room. If, however, the person against whom a search is directed is a long-term guest and has a section of the premises set aside for exclusive personal use, the host may not consent to a search of that area of the premises. Reeves v. Warden, 346, F. 2D 915, 4th Sir 1965. In addition, a host may not consent to a search of an item over which she lacks common authority, such as items that are obviously the exclusive personal property of the guest. State v. Edwards, 570A, 2D 193, Con 1990, held that although a host... So we heard you. So another thing that's important to note when it comes to like your personal property, even like items that are closed, I learned about this honestly this week for this week's reading. So let's say you're in public, right? You have a book bag, or like a book bag that's closed, that's not clear. Let's say I have a suitcase, right? My suitcase, my carry-on is pink. I had a red one, it broke, so my mom gave me hers. So my new carry-on is pink, right? And it's closed. I'm outside in the airport, carry-on's closed. You can't see through it, right? Let's say law enforcement officer were to stop me randomly
Stop and frisk is real. It's not good. Generally, stop and frisk is discriminatory in nature. I can do a separate video on that if you would like. But let's say I'm stopped on the side of the road or in the airport, and officers are like, come up to me, and they're like, okay, we need to ask you some questions, right? Like, officers, they can do that in a public space. They can walk up to you and just start asking you questions. You can answer the questions. You can choose not to answer the questions. They can do that. So let's say I answer the question, and then an officer's like, okay, well, I would like to seize your bag for maybe like an hour, like for 30 minutes. They seize my bag. It's in a room. I would say, okay, you seize my bag. Why did you seize my bag? Do not want to search my bag without search warrant, things like that. Without consent, they can't really search your bag. I mean, they can search it if they have reasonable suspicion to believe that a dangerous weapon may be in the bag that can like endanger individuals' lives. They can do that, but generally they cannot search your personal property without your consent. They need your consent to do that, or they need a search warrant to do that, even in public spaces, guys. So it's really good to elaborate that public-private spaces, because they can stop you in public private spaces. They can arrest individuals based in public spaces, generally without an arrest warrant. If they've seen you commit a crime, or if they have like reasonable suspicion to believe you commit a crime, they can do that. But when it comes to like the searching of private property, if it's closed property, if they do not have like probable cause or reasonable suspicion to believe that a dangerous time sensitive item will be found, then they can't search without consent or without a search warrant of your private property. A bag that's closed and not clear. Now, if the bag is clear, that's a different story. They can really see what's in it.
Lessee of an apartment could consent to a search of her apartment. She could not consent to a search of a...
Breakfast time. I'm not hungry, and all I have to eat is my mom's food, and I'm trying to stretch that out. So I'm good to love her kitchen.
Quest's backpack. Likewise, United States Vehically, 608, FSUP 1065, SDGA 1985, held that a consent to search a home given by the home's occupant did not authorize a search of a guest's travel bag found in the living room. The guest had done nothing to diminish his natural expectation of privacy in the contents of the bag. The host lacked common authority over the bag, as she had not been authorized to open or use the bag and had not in fact opened the bag. See also,
And then, really clearly, I need to put this distinction in for some people. Well, two distinctions in. One, as I always say, I'm just telling you this information that I have learned in class or am learning that's knowledgeable. So do not go, if you run into a law enforcement officer, guys, never go and be like, uniquely Mia told me this, so like you can't do this. Don't do that, guys. Don't do that. And number two, you may be wondering, I just went about, law enforcement officers can't search like my personal property, like, or they shouldn't search my personal property without like my voluntary consent, or without my voluntary consent, or like without a search warrant. However, when we enter airport spaces, guys, when we go through TSA in the airport, I'm not sure, do they have law enforcement officers, or is I think TSA may be a form of law, like a form of law enforcement officers, TSA. But anytime like I go through TSA, sometimes when I'm coming home and I'm going to school, they always search my bags. Why? Because there's food in that bag. So via that search, when they search my bag for food, when they open my carry-on, I'm voluntarily consenting to that search to occur. And two, if I do not voluntarily consent for TSA to like pat me down sometimes, or like to open my carry-on bag and search it, I'm not going to get through security. I'm not going to get on my plane. Why? Because that is a type, I discussed this earlier. Check out my like video that I made. That is a type of border search. Border searches are the ultimate special needs search, guys. And this is saying these special needs searches, if you want to get into this country, if you want to get on this plane, you are going to consent to this search. If you don't consent to the search, you're turning around and you're not getting through TSA. You're not getting on your plane. You're not getting in that country. So those are searches. It's kind of like when you buy your airplane ticket, or like if you decide to drive over to Canada or like to Mexico and you have to go through the border and they want to search you, you are voluntarily consenting to say, you know what? You're going to search me and I'm going to agree to this search. So there are like, obviously there's like circumstances where searches are you kind of don't have a choice. You have to go through with the search if they're going to search you. But like, yeah, you can always deny TSA to search you. You're just probably not going to get on that plane. Stu Lover Kitchen said, this why some businesses require employees to use clear see-through bags at work. Exactly. Because they don't want to go through the hassle of probably like of employees saying, no, you can't search me. And then they have to get like search warrant, have to try and convince the individual. But then again, law enforcement officers, you don't really want to try and convince people to like get a search, because if you try to convince people, that is a form of like coercion or cohesive search where you kind of like force people to do the search, and that's not good. So yeah, that's exactly why like clear bag policy. You just look, you see, no other like nothing else is really needed in terms of like the legal field or whatever.
United States v. Taylor, 600 F 3D 678 681-85 6. SIR 2010. Host sole female tenant of apartment lacked apparent authority to consent to police search of a male guest's closed shoebox when it was found by police in the corner of a closet in a little used spare bedroom underneath male clothing, and when the host did not have permission from the guest to open the shoebox. Employers and employees. This section will first discuss an employer's ability to consent to a search of certain parts of the employer's premises. Next, it will explore an employee's ability to consent to a search of his or her employer's premises. Employer's ability to consent in general. An employer may consent to a search of any part of the employer's premises over which the employer has exclusive or joint authority and control. State v. Robinson, 206A, 2D 779, New Jersey, Super 1965. Held that an employer could validly consent to the search of an employee's locker in the employer's plan. The employer owned the premises. Furthermore, under the terms of a contract between the employer and the employees' union, the employer retained a master key to.
Don't go to work thinking it's your space, guys. You do not own your office of employment. Your employee can give voluntary search free. They don't own it. Then the boss gave them ownership to say, you know what? You can give officers voluntary consent. That is like a public space. It's just a space where you work. Good morning, Holly. How are you doing this morning?
All employee lockers. Likewise, in United States v. Ziegler, 474 F. 3D 1184, 9th SIR 2007, the court found that the employer could consent to a search of an employee's workplace computer, which the company owned and had informed employees was subject to periodic monitoring and inspection. An employer may not, however, validly consent to search an area set aside for use by an employee and within the employee's exclusive control. United States v. Block, 188 F. 2D 1019, DC SIR 1951, held that an employee's boss could not validly consent to a search of a desk assigned for the employee's exclusive use. In the absence of a valid regulation to the contrary, the employee was entitled to, and did keep private property of a personal sort in her desk. Her superior.
Well, that's interesting. So it's saying the employer can consent to an employee's search of an employee's like workplace laptop, the locker room, and any other public spaces. In the corporation. However, according to this, the employer cannot provide voluntary consent to allow officers to search the employee's desk, personal desk, because that's kind of like their personal, in their own, like in the employee's exclusive control, according to this. So that's interesting. Holly said, good. Just trying to wake up. Well, wow. Awesome. Thank you. I appreciate it. That's awesome. You decided to wake up and the first thing you did after opening your eyes and probably saying good morning to your family members was tuning in to the live stream. So shout out to Holly. Shout out to all you guys. Really appreciate that. I hope you have an amazing day, Holly, Stu Lover Kitchen, Terrifier, everyone else on the live stream. Remember, be a little active. Be a little productive, whether that's like going on a walk, and stay positive, guys. Right now, what I'm doing, Holly, I'm reading, doing like some criminal justice reading right now. So as you know, or if you don't know, I make criminal justice long form videos on my channel. So most of the information that I make videos on, it generally comes from like academic journal articles, but this semester mostly from like my criminal justice textbook, because that's what I'm learning about this semester. So this is like the raw data, I like to call it. And in the videos you get like the main points and the more fun version of the data. But before I could give you like the fun version of the data in a nice video, 15-minute video, I have to spend maybe like 2-3 hours, if I'm lucky sometimes, reading the full chapter for you guys. So this is what we're doing right now.
Superiors could not reasonably search the desk for her purse, her personal letters, or anything else that did not belong to the employer and had no connection with the work of the office.
Good morning,
Their
good morning,
consent did not
Christina.
make
How are you
such
doing?
a search by the police reasonable. 188F, 2D at 1021. See also United States v. Gonzalez, 328, F, 3D 543, 548, 9th Sir 2003. Of course, one may have an objectively reasonable expectation of privacy in private work areas given over to an employee's exclusive use. Internal quotations omitted. Part 2. Exceptions to the search warrant requirement. Employees' ability to consent. An employee's ability to consent validly to a search of the employer's premises depends on the scope of the employee's authority. The average employee, such as a clerk, janitor, maintenance person, driver, or other person temporarily in charge, may not give such consent. United States v. Block, 202, F sub 705, SD New York 1962, if, however, the employee is a manager or other person of considerable authority who is left in complete charge of important duties for a substantial period of time, the employee may validly consent to a search of the employer's premises. See United States v. Antonelli Fireworks.
You know what this reminds me of too? Now that I'm learning about like consent searches and how like employees and like employers can consent for individuals. So I'm a resident assistant and I live on campus, and my residents, they live on campus as well. And like throughout the semester, guys, I'll get emails. My residents will get emails and they're like, maintenance is going to be conducting like a facility search on your unit. In the past, I had to do something known as health and safety inspections, and that was where myself as an RA, I would go in residence unit and check their unit just to make sure like it's clean, they don't have like any illegal items or like any prohibited items on like the campus. So that's a form of like, that's a consent search. Like before you move on campus, RAs, residents, we all have to sign like a housing agreement. I've never read the housing agreement, it's so long, but I bet you if I were to take a look at my housing agreement and I read that housing agreement, some form, some language that's going to imply a consent search is going to be in that housing agreement for those like facility searches, RA searches to happen in the unit. So like even in a residence hall, guys, if you guys are a grad student, a college student, a high school student who's going to be living on campus soon, that's not your space. It is your space, but it isn't, because housing coordinators, higher ups in housing, they can provide that voluntary consent for you to have your unit searched. It's like if I'm dealing with an incident, guys, and I need to enter into a residence room, I have to ask my supervisor, hey, can I key into this unit? If they're like, yes, you can key into this unit, they gave me voluntary consent to enter into this student's room to search that room. And that is a form of voluntary consent that they provided for the student.
Fireworks Company 100.
That's good. I'm write that down.
F 2D 631 2D SIR 1946. See also Burt v. State 2011 WL 3211249 Tex Act 2011 A reversed on other grounds by Burt v. State 396 SW 3D 574 Tex Crim Act 2013 and based on what Director of Public Safety Shackelford knew at the time, i.e., that the office manager was an authorized signer on her employer's business bank accounts. Shackelford could have reasonably believed that the office manager, by reason of the nature of her employment, had common authority or apparent authority to consent to the search of her employer's office locations. Under this employee standard for consent searches, typical babysitters who are assigned to watch children for short periods of time have insufficient authority over the premises of their employers to give a valid consent to search the premises. People v. Litwin, 355, New York S. 2D 646, New York. Active 1974, and though live-in babysitters who type Cali reside for longer periods of time in the home to care for children may be able to validly consent to a search of areas of the home to which they have access. They, generally cannot consent to a search of the homeowner's bedroom. This was the holding of United States v. Deering, 9, F. 3D 1428, 9, SIR 1993, where the babysitter had a room in the home and lived there for approximately 6 months to care for the homeowner's special needs children. The court in Deering found that the live-in babysitter could not consent to a search for a machine gun in the homeowner's bedroom because the babysitter did not have mutual use and joint access or control for most purposes over the bedroom. 9, F. 3D at 1430. A reasonable officer should have known that the babysitter lacked this kind of use and access or control over the bedroom. School officials and students, elementary and high school students. A police search of a high school student's locker, based on consent given by a school official, is valid because of the relationship between school authorities and students. The school authorities have an obligation to maintain discipline over students, and usually they retain partial access to the students' lockers so that neither has an exclusive right to the possession and use of the lockers. In a case in which police opened the locker of a student suspected of burglary with the consent of school authorities and found incriminating evidence, the court said, although a student may have control of his school locker as against fellow students, his possession is not exclusive against the school and its officials. A school does not supply its students with lockers for illicit use in harboring pilfered property or harmful substances. We deem it a proper function of school authorities to inspect the lockers under their control and to prevent their use in illicit ways or for illegal purposes.
So if you are in school, I'm assuming lockers are probably in high school settings. It could be middle school, I don't know. But like, you don't own your locker, guys. You can prevent your peers from entering your locker, but you, if your teacher, your principal, your counselor, if they want to search your locker, they can do that in school. Christina, I'm doing good. How are you doing?
Purposes. State v. Stein, 456p, 2D1, 3, Can 1969. Though not squarely a consent to search case, Zamora v. Pomeroy, 639, F. 2D 662, 670, 1981, held that high school officials have a right to inspect student lockers and relied explicitly on language from the consent to search context when it said that, inasmuch as the school had assumed joint control of the locker, it cannot be successfully maintained that the school did not have a right to inspect it. Zamora found no Fourth Amendment violation when school officials permitted police to enter a school to conduct searches of lockers using drug-sniffing dogs. The court in Zamora acknowledged in dicta that high school officials may consent to an inspection by law enforcement officers of student lockers. 639, F. 2D at 670. Furthermore, in Commonwealth v. Carey, 554, NE, 2D 1199, 1202, Mass 1990, the
Let's read over here. Just repeating the same thing. Okay, let's go down. I'm gonna repeat the same thing. Christina said, I'm going through a lot. Also holding everything in. I'm also going through depression. I remember last time you said that, Christina, you mentioned that you had like a counselor or like a therapy appointment coming up soon. Have you attended? Were they able to help you? As I said, like, as my mom said too when she was here, we all struggle with things, so feel free, continue to like push through, stay positive about it, and like speak to your family members, speak to your friends. As I said earlier, I know you mentioned that like you have like a therapist that you are working with, so definitely communicate with that therapist, and just remember that you matter, Christina. You are important. Your opinions matter. So, yeah, continue to stay positive and try to do one thing each day that makes you happy. If that's reading a book, if that's watching your favorite TV show, if that's going outside, if that's cleaning, make sure to like do that one thing. Try and do it every day. And hopefully that helps. Also, try to implement like positive affirmations on your channel. Positive affirmations, if you don't know, I mean, you go in your bathroom mirror, you just like wake up when you say a prayer, say your goals, and just say positive things about yourself to make yourself feel better, like internally. Aiden said, Holly, I saw your channel. Christina said, I'm going to sleep over at my brother's apartment today. Okay, nice. How do you feel about that? Are you happy about that? Not happy about that, Christina?
In general, the only person able to give a valid consent to a search is the person whose constitutional privacy interest against unreasonable searches and seizures would be invaded by the search if it were conducted without consent. Consent to search may be obtained by police from a third party who possesses common authority over or other sufficient relationship to the premises or effect sought to be inspected. Consent to search may be obtained from a third party whom the police, at the time of entry, reasonably believed to possess common authority over or other sufficient relationship to the premises or effect sought to be inspected. When valid consent is obtained by police from one co-occupant to search a residence on a particular occasion, and another co-occupant of that residence is physically present on this occasion and refuses to consent, police may not enter the residence without a warrant or the presence of some other exception to the warrant requirement. This rule does not apply if the refusing residential co-occupant is absent when another co-occupant who is present validly consents. Thus, police may search residential premises when one residential co-occupant who is present validly consents in the absence of another objecting co-occupant. A person may specifically authorize another to consent to a search of the person's property. Bailers and bailees. A bailee is a person in possession of someone else's personal property with the lawful permission of the rightful owner, also referred to as a bailer. Depending on the level of control a bailee has over the personal property of another person, the bailee may be able to give legal consent for a search of that property. 403. Part 3. Exceptions to the search warrant requirement. Bailee in full possession and control of personal property. A bailee of personal property may consent to a search of the property if the bailee has full possession and control. For example, in United States v. Besher, 961, F. 2D 1380, 1382-83, 8. SIR 1992, the court found that defendant's girlfriend could provide valid consent to police to search defendant's car because the defendant had given his girlfriend permission to use the car and she had placed her own license plates on the car. The court reasoned that the defendant had thus assumed the risk that his girlfriend would permit the vehicle to be searched, and in United States v. Jackson, 598, F. 3D 340, 342-43, 347-48, 7. SIR 2010, the court determined that defendant's mother could provide valid consent to a police officer to search the defendant's computer and computer case because defendant had allowed his mother to borrow and use the computer, because defendant's mother, Eden, had the apparent authority to consent to a search of the computer case. The district court properly denied defendant's suppression motion to suppress a gun found in a pocket of the case. First, there is no evidence that Officer Dexheimer was aware of anything that would have alerted him that Eden did not have authority to.
No, I am back at school, Christina. So yeah, we are back at school. So we are going to get like educational content and like more like one-on-one chats for live stream wise. But don't worry, when I was home for spring break, I did vlog like a lot of adventures or a lot of things that my mom and I did. So I have yet to edit all the videos, but I do plan. I have enough videos. If I drop one video a week, you'll have videos from me until like April, like the second or third week in April. So make sure to set your alarm for Wednesday at 12 a.m. Wednesday, 12 a.m. That's when I'll have videos dropping. Christina said, I'm doing karaoke and then I'm going to do Just Dance. Okay, that's really, really cool. Where is my mom? You asked me where my mom is or where your mom is, Christina. My mom's not with me. She's at home. She remained home.
A consent search occurs when a person allows a law enforcement officer to search his or her body, premises, or belongings. Consent searches are convenient for law enforcement 106 officers, requiring no justification, such as probable cause or a warrant, but consent EE. Part 3. Exceptions to the search warrant requirement. Searches also present many opportunities for abuse. For this reason, courts exercise a strong presumption against consent searches, and place a heavy burden on prosecutors to prove that they are voluntary. Voluntariness depends on the totality of circumstances surrounding the giving of consent. Among the circumstances considered are force or threat of force by police, fraudulent or mistaken claim of police authority, misrepresentation or deception by police, arrest or detention of consenting person, consenting person's awareness of the right to refuse consent, to search, police informing consenting person that she is free to go leave, clearness and explicitness of consent, notification of counsel and the provision of the Miranda warnings, and the physical, mental, emotional, and educational characteristics of consenting person. The Fourth Amendment does not strictly require that a lawfully seized person be advised that he or she is free.
I already know that. I don't need a summary. All right, guys. So we read the chapter. That was a lot. So now I'm going to go in and try to highlight. I do have this like peachy color, and I do have this yellow. I think the yellow may be out of ink. Wait, no. The pink has more ink than yellow. So we're going to highlight with these two colors. And I like to highlight because makes it look a little pretty, and two, I've noticed that like it definitely helps with being able to find important information a little bit easier. Like it's really weird, like sometimes I highlight with green and pink, green and yellow, but they said consistency is better. However, I guess my brain just associates a new color with each chapter, so it's easy for me to like pick out the important points via that way. Christina, it's around 8:40 where I am right now, a.m. So welcome to the stream. If you've just joined the stream, Uniquely Mia here. I just finished reading my Law and the Legal Process textbook. We went over consent searches in chapter 9. Stay tuned. I will be making like a full-length traditional long-form video for you guys, essentially summarizing like the main points related to this chapter. So if you guys were here since the start of the live stream, you definitely got a sneak peek into the full video. What's it going to be about? After this, after I finish highlighting, I am going to move on to my public administration. I do have to like start some public administration reading this week, or today at least. The week is on lower, but today, because I want to try and get a little bit ahead of that. I'm not sure. I'm not going to live stream that reading. However, before I do that reading, I will be typing on my computer. Like I had class yesterday, so I want to translate some of that notes onto like a Pages document. So I'll probably keep you on for maybe a little bit of the typing, not the full thing, because my phone does have the charge, has 21%. So we're going to see how long that 21% lasts us. So you guys may get like some ASMR typing in between, but would love to know how's your day going or your morning if you just woke up, if you're tuning in from like the other side of the world. What time is it for you guys? If you are already in the afternoon, what did you do for your morning? And welcome back if you are a returning supporter. Shout out to you guys. Thank you so much for your continued support. If you are a new viewer here, please consider liking the video and subscribing to the channel to become a supporter. I post educational videos, Eat With Me's technology videos, fashion videos, travel videos, graduate school videos, and so much more, guys. So definitely consider joining the Uniquely Mia community. You are welcome for your uniqueness. There is a PowerPoint and a lecture video for this same chapter 9, but I think I may leave it for this weekend or maybe even Monday. I may change my mind later on this afternoon after I take my break. I can come back to it and be like, you know what, I just want to like finish it now and just read the chapters. I mean, go through the PowerPoint. I may not go through the lecture videos today because those are generally really long. It's like 30 minutes to an hour. Sometimes the lecture videos are 2 hours, but I do like watching the lecture videos because it has like valuable information. Professor says stuff that's going to be helpful like for exams, sneak peeks into stuff, so that's definitely helpful. And you watch the full lecture videos, guys. It's something person. Right. This is notebook number 2 for this criminal justice class of this semester, if you were wondering. This is what I started with in January, and this book is filled up. So I think they have a few pages, but it didn't really make sense for me to use these pages because I knew that it wouldn't be enough, and I would hate to break up 2 textbook chapters into 2 different pages. So I think I told somebody at the start of the semester, I generally use 2 notebooks per class just because I take a lot of notes on my in my notebooks because I handwrite my notes. And like some of you guys may then wonder, why don't you just buy one of those notebooks that has maybe like 200 or maybe in 500 pages? I've seen them. 1, because those notebooks are generally expensive, and 2, I don't know, I've just always, like, when I look back into like my earliest memories, I've always used these notebooks. So use these in elementary school, use these in high school. I mean, obviously, like, when I was in the Caribbean, I had their notebooks, but mainly it was these type of notebooks that my mom used to buy for me. So I just like the format of these books, so that's why even if it takes 2 to 3 books per semester, I just stick with these books and I just continue to use them. And generally, if you buy it on sale, oh, it has 80 sheets. That's why I'm always running out. 80 is nothing, but yeah, I just always use them, so that's why I continue to use them. So yeah, we are on to the second book. This book is ending too. I have to go to Walmart because I'm gonna have no books left. Like, this is for my public administration. This is gonna be finished very, very soon, so I'm gonna need to get another one for this too. Okay, so we're going to fundamentals. Yesterday in class, we went over various like policy program evaluations, things like that. So I'm literally going to summarize information and try to connect it to the reading that we had to do. Reading. Close chapter 10. Next card. I do draw in my notes if you haven't noticed. So before that, let's highlight a little bit because that's going to help me organize this in my head a little. Okay, so that's the PowerPoint. It's the most important part. All right, guys, so I'm going to end the stream here for today. I'm gonna just continue typing this out on my computer. It's literally translating notes. I'm gonna be doing this week by week until like I don't know, classes anymore. I feel like it's just going to be helpful for me later on. So hopefully you enjoyed this stream. I do hope that you learned something from this live stream, and definitely stay tuned for more live streams coming soon, and definitely check out some of my full-length traditional YouTube videos if you haven't already. Have a great day, guys. Thank you so much for watching. Bye.